2, 1. Thank you. Let's resume the hearing. Please bring in the candidate for the position of the judge of the High Anti-Corruption Court of Ukraine, Kimstachov Oleh Sergeyevich. The matter is heard about the compliance of Kimstachov Oleh Sergeyevich to the criteria outlined in Part 8 of Article 8 of the Law on the High Anti-Corruption Court of Ukraine. We have the former international experts Gabriel Gyotkaite, Norman Aas, Robert Heinz Brodkais, Jessica Lott Thompson, John O'Sullivan, Lyubila Vodka, Vedamir Yaroslav Dubr, Malka Dusyuk, Kolюш, Владимир Луганський, Руслан Мендік, Олексій Умелян, Андрій Пасічник, Роман Саподач, Руслан Сидорович, Сергій Чумак, and Галина Шевчук. You have the right to file a recusal for the members of the board under the legal rights, file motions, provide explanation, voice your opinions, denials on the matters being discussed, and appeal the decision as provided by the law. Please note that the special joint meeting will not hear any new materials submitted by the candidate unless the opportunity was given to provide the materials and the candidate or another person did not provide them to the Commission or the Public Integrity Council. If there are any significant grounds on the submission of the candidate with the majority of the vote of the Commission and the Public Council, the decision can be made to add some additional material on condition at least 3 members of the Public Integrity Board of International Council voted on it, and I'm giving the floor to Kolюш to give the background information. I would like to notify that I'm the judge of the High Anti-Corruption Court of Ukraine under the provision of the Article 100. There are no grounds for my recusal, but I felt that I should state this as the candidate is also related to the High Anti-Corruption Court of Ukraine as the assistant judge. Oleh Sergeyevich, would you like to declare any recusals? I have no recusals. I would like to let you know that yesterday to the Commission address I filed my statement knowing that a member of the Commission Kolюš is a judge of the Hague, and as we worked together we did not know each other in person and I had no connection to the cases adjudicated by His Honor Kolюš, so I have no grounds to file a recusal of Judge Kolюš, and I would like to file no other recusals. Do you have any other motions? I have no further motions. Thank you. The rapporteur is Melnik Oleg Ivanovich. Over to you. Thank you. So, Kimstachov Oleh Sergeyevich in 2011 graduated from the National Legal Academy named after Yaroslav Mudry, having obtained full legal education of law. At that, he does not hold any scientific degrees, short biographies. Since 2008 to 10, he worked as a legal counselor. In 2012, by the decree of the President of Ukraine, he appointed to the position of a judge of Uman District Court in Cherkasy region. In 2017, by the decision of the High Council of Justice, he was dismissed from the said position based on his own voluntary resignation. In 2019, Kimstachov was a private lawyer and since 2018 has been working as the assistant judge of the Hague. So Oleh Sergeyevich has the experience of over 5 years of working on the judicial positions and speaks the state language. Also, it's worth noting that as part of the competition for the High Anti-Corruption Court, during the general legislative test, Oleh scored 136 points. During the test of the cognitive ability, he scored 55 points, and based on the practical assignment completion, he scored 115 points. Thank you. The briefing is over, handing the floor back to the experts of the Public Council of International Experts, and the floor is given to the chairman, Mr. Robin Brunheisen.
Thank you, Mr. Melnik. My name is Robert Broekhuizen. I'm a lawyer from the Netherlands. I would like to discuss with you, or we would like to discuss with you, a few issues: your history, issues of disciplinary nature, some financial issues, and maybe also your declarations. And I have agreed with the rapporteur of the HQCJ that I will do first discuss with you your background. Then I will hand over to Mr. Melnik about the disciplinary issues that have existed. Then I will do a bit of financial issues. I will hand back to Mr. Melnik, and he will deal with the remaining questions. Is that okay with you?
Absolutely, of course.
I would appreciate if you would be concise in your answers, because the experience I have is that sometimes the answers may take very long, and we only have limited time. So it would be handy if you would limit yourself by answering the questions to, let's say, 3 minutes. Is that okay? Yeah. Well, thank you for being here. Thank you that you applied to this position, and thank you to be willing to speak to us in this great setting, in this great room. Mr. Kimstachov, can I say Oleg to you? You can say Robert to me. You have been working as an assistant of a judge in the High Anti-Corruption Court since 2019, yes? Can you tell us, within the 3 minutes, why you want to become a judge in the High Anti-Corruption Court, and explain to us that you are suitable to do so?
As for my motives to work as a judge for the High Anti-Corruption Court, it comprises several reasons. On a professional level, the High Anti-Corruption Court, following the competitive selection, employs some of the very best lawyers of Ukraine, both the judges, the lawyers and academics. So it's a chance to be in a team amongst top professionals who are professionally developing. It's a chance of professional development for me personally. It will also be a career step upwards for me from working as a local judge and then working as a judge assistant for HAC. Also, I would like to state that the Anti-Corruption Court has the practice of receiving submissions by the legislators for review, for the judges to say their opinions on the drafted laws. So it's a chance for me to influence the laws and the regulations that will then be applied on the judicial bench in cases. The High Anti-Corruption Court is a team of allies because all the staff has been hired competitively. The head of the staff is greatly interested in creating all the prerequisites for the court staff and for the judges of the court, for them to be in a good position to do their job well and not to have to worry about the material or technical support of their operations. It's a good working climate in the team. Also, by nature, by character, I feel that I enjoy and I'm capable of hearing disputes between the people and objectively, independently, effectively adjudicating them and making the judgments. This is what motivates me in short.
Thank you, Oleg. If I read my notes, I have noted that before you started to work in the High Anti-Corruption Court, you served as a judge in the Uman District Court until 2018 for 6 years. That's correct, huh?
This is so. From the 3rd of May 2012 until the 3rd of October 2018, I served as the judge in Uman District Court. 5 years of my judicial term expired in April 2018.
I've noted down that in March 6, 2018, you received a negative conclusion on compliance with the criteria of integrity and professional ethics from the Public Integrity Council, the PIC. Is that correct?
In March 2018, there was a conclusion of the Public Integrity Council. And it wasn't the International Public Integrity Council as part of the qualification assessment for the compliance with the held position.
Yes, I have noted down that on March 27, 2018, you had an interview with the High Qualification Commission regarding this qualification assessment, and that as a result of this, that High Qualification Commission addressed the High Council of Judiciary to open disciplinary proceedings against you. That's correct, huh?
The board of the commission decided to approach the High Council of the Judiciary for them to consider a complaint filed on me before the interview to decide if there are grounds for disciplinary proceedings or not, and if there are grounds for them to consider the matter and make the decision.
So disciplinary proceedings were opened, and in 2018 by the HCJ, and in October 23, 2018, the High Council of Justice dismissed you at your own request. That's correct, huh?
Mr. Robert, in October 2018, I was dismissed, and this is correct, but the start of the question about the disciplinary proceedings weren't entirely clear to me. Are you asking if there is a connection between my resignation and the disciplinary proceedings against me?
Well, I didn't ask you that, but if you want to answer that, please go ahead.
The questions from the international experts asked me whether what was the reason for my resignation during the first competition for the High Anti-Corruption Court, and whether what my motives were. I resigned from the first instance court for the reason of applying for the first round of competition for the High Anti-Corruption Court, because in 2018 there was one opened disciplinary proceedings on Yaroshinska case in September 2018. A disciplinary penalty was imposed by me by the disciplinary chamber of the High Council of Judiciary, but I appealed the decision in October, and accordingly, I was hoping that it will be reversed by the High Council of Judiciary. Still, the law at the time provided a limitation for the individuals on whom the disciplinary sanction is imposed for their participation in new competition. So, considering this provision, I decided that I would resign of my own accord to have the right to apply for the first competition for the hack. My resignation from the first instance court is not related to any disciplinary proceedings. The judicial file materials provided to the Public Council of International Experts. My explanations are provided to all the questions by the High Council of Judiciary as to the complaints. So I didn't feel that any complaint that was seen by the HCJ could be the grounds for my dismissal.
So I understand there was no connection whatsoever between the complaints against you and your stepping down. That's what you say. It's correct?
Yes, your understanding is correct.
I've noted down here that so you started to be part of the competition for the position in the High Anti-Corruption Court. And I've noted down that in January 21, the previous composition of the High Qualification Commission and the PCIe terminated your participation because of existence of reasonable doubt regarding your suitability for the position of a judge in the High Anti-Corruption Court. Is correct? Huh?
This decision was made in January 2019, and the decision stated three grounds that, in the opinion of the Commission and members of the International Council of International Experts, preempted the positive decision on me. One point, that I held a position of a local council in a local council for the period of less than 10 years before the submission of the documents, and two other matters related to disciplinary proceedings against me and one of the civil cases that I sat on.
Now, what I'm struggling with is how we can consider that there is no reasonable doubt against you if we have a negative decision of the PIC, a negative decision of the former HQCJ, a negative decision of the former PCIe, how we can consider you. So explain to us that even though this background exists, why now you think you qualify for the position of a judge in the High Anti-Corruption Court. That should be a judge that where anyone of the people of Ukraine can have full trust that they are in compliance with the rules and regulations and obligations of a judge, and that they are completely suitable, and that there are no doubts about integrity or professional competence of such a judge. So please explain to me in 3 minutes what has changed and why you think you are able to participate now.
as for the circumstances stated in the joint decision of the Public Integrity Council and HQCJ, I can say the following. Following my tenure as a local council, it's been more than 14 years that have passed. Then this does not preclude me from applying for the competition. As for the disciplinary proceedings, they were imposed on me in 2016 for hearing on an administrative case and violating the reasonable term of adjudication of the case set by the law, and the disciplinary sanction was imposed on me by the High Council of Justice in 2018, which was reversed in January 2019.
But it was also related to the violation of the terms during which cases should be heard. About those circumstances, I can say that after that, after administered justice, there more than 7 years have passed, and I had enough time to evaluate my own work as a judge and to work on removing those reasons or drawbacks in my work that I had had before. In my responses to the questions of the international experts, I provided information about the trainings that I undertook, including on how to organize the work in the court, how assistant judge should work, and how cases should be heard collegiately, and how the assistant judge should draft the decisions, and the issues related to conflicts of interest in the work of the court staff. And while working at the High Anti-Corruption Court, I saw how one can organize one's work well, how they can plan their cooperation with the judge's office and with other judges when hearing cases in a collegiate way. So the period of my work as a judge, yes, I made mistakes as regards organizing my work, as planning the meetings, the hearings, and the time to be allocated to hearing those cases. I realized that at the moment I feel that I am capable of organizing my work in a well-built and planned way and to cope with the necessary tasks that a judge has. And as regards the third circumstance, that was related to the case that I heard as a judge of Uman District Court. It was a case where the plaintiff at that time worked as another judge in the court. I heard that case. On that claim, I heard the case and I made the decision on the merit. That was probably one of the cases that I remember most often in my life, because it became for me a kind of a nightmare and a barrier for my career development. During the first competition for the HACC, I had the time and the possibility to think about those actions that I carried out while hearing that case, and I could see how the issue of recusal is done at the High Anti-Corruption Court. And I could read a lot about the case law of the European Court of Human Rights in terms of recusal. And I can say that I have made these lessons. I have learned these lessons. I understand that the judge should treat more carefully the situations, especially as it is seen from the outside, when one judge hears a case with participation of another judge. At that time, Yes, I'm about to finish. At the time when I made that decision on the basis of the case files and on the basis of the law, I was convinced that I acted correctly. Later, I could look at my actions, let's say, from the outsides and change my attitude to such situations and how they should be resolved. Thank you.
Yes, thank you. Before I hand over to the rapporteur of the HQCJ, I wish to make one remark, and I just would request you to answer this remark in a short answer. I have always learned, because you say and you confirm that in the past you made really serious mistakes when you were a judge, and that you have changed your position because you have learned about your mistakes and you will now do better. I have always learned that the past is the best predictor of the future. And you say that you have changed and you will do better, but I do not see any real proof that you will. So how can you make us believe that you indeed will do better than you did in the past?
Well, in those past years when I have worked as an assistant judge and not a judge, and therefore with my decisions or actions as a judge, I cannot convince you. The only thing I can say that as an assistant judge, I perform the tasks that the judge gives me. The judge I have worked with, but since 2019 for the first 2 years, was an investigative judge, and therefore there were very many cases that required urgent preparation, drafting decisions. These were the cases on preventive measures and arrests, on search procedures, and therefore the judge would quite often engage me in that work, especially with overtime, and there are all kinds of orders made at the High Anti-Corruption Court confirming that in 2022, you can find an order of the court that, according to my own request, I would work with overtime, and therefore I can be engaged by the judge if need be to perform some urgent tasks, even at the working hours that go past the normal working day. The judge didn't have any complaints about my work.
Thank you. I will hand now over to the rapporteur of the High Qualification Commission, Mr. Melnik.
Thank you, Robert, for giving me a chance to ask questions about some ethical behavior of the candidate. Well, I would still like to get back to certain issues where I believe that the outsiders can be interested in them and can raise some doubts unless the candidate clearly explains his reasons about certain decisions that he has made. As it has been already said here, Oleg, you were a judge, and you dedicated 6 years of your life to the work of a judge. As I talk to candidate judges, and as I find out what their motivation is, they would often explain that the position of a judge is the highest level of professional development. Therefore, you have reached that highest level. And I understand that you worked for 6 years diligently and honestly. What happened in 2018 when during a qualification assessment you decided to step down? Can you clearly explain what your reasons were? Well, at once let me ask you that this quite an unusual version when you said that staying in the position of a judge would interfere with your desire to become a candidate for the position of the High Anti-Corruption Court doesn't look very convincing, because our legislation does not require any prohibitions for the active judges, sitting judges, to participate in the competition. So can you please explain your reasons in view of what I have just asked you about? Well, first of all, being a judge does not interfere with the possibility to participate in a competition. That is really so. But I've said that a disciplinary sanction could become a barrier if it was imposed on me by the High Council of Justice in September of 2018, because on the time when the issue of allow me to participate in the competition for the HACC, my complaint about such a decision to impose a disciplinary sanction against me, it was not heard. It was heard only in January 2019. According to the law of Ukraine on the status of judges, the presence of disciplinary sanction would become an obstacle for my participation in any competition. In other words, you have decided to step down as a judge in order for the disciplinary proceedings that had been opened against you would not interfere with your decision to become, with your desire to become a judge of the High Anti-Corruption Court. Is that so? Yes. In fact, that was the only reason for my decision, as provided by the law, and as regards disciplinary proceedings because of the qualification assessment. I want to know that during the period between May of 2018 and until October of 2018, from a member of the High Council of Justice, I had received requests to provide explanations to those decisions, and I provided quite well-elaborated answers to confirm my reasons for every question that was put to me. I didn't have any doubts that as a result of those disciplinary proceedings, the disciplinary chamber of the High Council of Justice would not impose disciplinary sanctions against me, and I was able to have a positive assessment, disciplinary assessment. Fine, thank you for your response. To get back to the disciplinary proceedings, this question has already been asked, but I would like to clarify some aspects. The decision was made against you, it was negative, but I understand that it was quashed later. At the same time, as part of that decision, certain circumstances were identified showing that you had violated the terms of hearing cases that you worked with. Was that really so? And can it show that your competence is not sufficient enough? The decision of the disciplinary chamber of the HCJ stated that those civil cases that I heard them for a year, whereupon the decision was made, entered into the register of decisions with a delay, which violated the terms. That really happened. Was not only my own attitude to the case that affected the terms and the period of time required, but also the behavior of the other parties and the disease of the defendant. So that's why it took so long. Eventually, the decision was made, and with a decision of the Supreme Court, it was not changed. About whether it confirms that I am incompetent, I believe that as a judge, and as regards the quality of the cases I heard and the decisions I made, it was quite high, and it was not lower than the average indicators, and even higher than that. Now, as regards the case for which disciplinary complaints were launched, Yes, it's true that sometimes complaints were made about my failure to comply with the proper period of time, but eventually, if you look at the final results, the higher ranking courts never confirmed those complaints. So you believe that the facts that were established during the disciplinary proceedings, the circumstances that showed that your decisions were entered too late into the register, did not show that you are incompetent. All right, thank you. Now to get back to the issue that you have mentioned yourself, which is hearing a case where the plaintiff was the judge of the same court where you worked at that time, which is Uman City and District Court of Cherkasy region. Do I understand correctly that you confirmed that you made a mistake, that you violated the procedural law valid at that time, as well as the Code of Judicial Ethics and other standards that require that when you have any doubts about your unbiased nature, that you have to recuse yourself or to inform, to provide information that can confirm that. Please. With your permission, I'd like to respond first to your previous conclusion. The fact that in 2018, no, in 2015 and 2016, those cases that I didn't comply with the proper timeline and those decisions were entered into the register too late. Yes, these were violations, but as a lot of time has passed since that time, I don't think that this can be used as a criterion showing my incompetence. It cannot be done so. As regards that civil case where the judge was a plaintiff, in my explanations to the international experts, I wrote that at that time I made a decision because of my internal convictions based on the case materials and the letter of the law, which meant that the judge cannot, on one's own initiative, demand to see evidence about certain circumstances that can be important for a case, in particular, as regards, for example, the issue of jurisdiction or to recuse oneself. I can say that today, I understand that in such situations, one has to comply with the general provisions of the law and the judiciary, which suggest that a judge should be independent, not only because of one's subjective attitude to the parties of a case, but also for the outsiders. It should look that the judge or the court is independent and unbiased. Right. As a note for our international experts, I want to say that at that time, Article 108 of the Code of Civil Proceedings, as well as today, Article 26, establish the procedures that make it impossible to hear a case if it is directly related to the judge of that same court where the hearing judge works. So the legislators believe that this is a situation that leads to the conflict of interest, and that in fact, it contains the mechanism about how to resolve such situation. In that case, that mechanism was not used, and the judge says that in fact he was forced to hear a case of a judge of that same court.
Отже, Роберте, я закінчив. Передаю вам слово щодо інших обставин, які потребують дослідження в рамках нашої співбесіди. Дякую.
I hand over to you, Robert, for any other matters that need to be examined in this interview.
Thank you, Mr. Melnick. Yes, certainly there are some you have filed an asset declaration in 2023, and in that asset declaration it is shown that you received a monetary gift worth of 549,000 hryvnias from your mother. Is that correct?
So in 2023, in my declaration, I stated such a gift from my mother.
Yes. Then we asked you a question in the first round of questioning, and then you stated, and I quote in translation, "As for the in-kind gift from my mother, it was a gift in the form of an intangible asset, namely Tether cryptocurrency stablecoin in the total amount of $15,000. Is that correct?"
This is so.
Yeah, then we were a bit amazed that your mother would have cryptocurrency because she's around 70 years old. Correct, huh? And in the second round of questions, you wrote to us that my mother did not personally receive cryptocurrency, and did not make transactions to transfer cryptocurrency to my crypto wallet. She is not personally a user of crypto wallet or crypto exchanges. Yeah, we have a bit of difficulty with it because in your declarations, you say that you received a gift from your mother. And in the first round of questions, you say that you got crypto from your mother. But it appears that you did not receive crypto from your mother. Is that correct?
In my declaration and in my answers to the two rounds of questions, I stated that this in-kind, intangible gift was received from my mother, but not directly, and not from her account on a crypto wallet or account on a crypto exchange, but through a wallet and address used by my brother, Sergei. I stated it's a gift from my mother because this asset was acquired by my brother with the money that she had loaned to him or provided to him to purchase the cryptocurrency through his account. So these were not money belonging to my brother, these were the savings of my mother. So I stated that the gift I received from my mother, and my brother Sergei was an intermediary who transferred the gift from the mother to myself.
That's what you said in the second round of questions. But in the first round of questions, you said that you received cryptocurrency from your mother. And now you say, I received the cryptocurrency from my brother, though it was money from my mother. That's correct, huh?
In the first round, I briefly stated the circumstances that could be asked of me by international experts, and I did not go into the details of the circumstances. Was in the second round, I provided the detailed explanation of the mechanism of the transfer of gift by my mother to myself. So it was true on both occasions, both circumstances were the same, but in one case it was succinctly stated. In the second case, I provide a detailed explanation of the mechanism of the transfer of gift.
The point is that from all the information you provided, it shows, I would say, only that you received money from your brother. And you have, let's say, explained to us in detail how your mother got the money and why she gave it to your brother. For instance, you say that your mother gave $10,000 to your brother in order to invest it in cryptocurrency. Yeah, if I think about it, that seems to be so unlikely that a mother of 70 years old the money she has, which is not a lot, gives to someone to invest it in cryptocurrency. Is that ordinary practice in your family to do it in that way?
At the time, my mother was 66. She was born in 1956. This happened in 2021. At the time, my brother, as I was saying, since 2017, has been interested in cryptocurrencies, and talking to his mother, he explained that this is a promising market, we can say, where money can be invested. So my mother trusted her son and gave him the money so that the money wouldn't just stay at home in cash, as at the time the interest rates on the deposit were very low, below 1% on annum.
You agree with me that the file does not contain any proof that your mother indeed gave the money to your brother?
As I was saying in my answers, my mother and my brother did not enter into a written agreement, and the money was transferred in cash when my brother would see her in a settlement where she is residing. But I did provide the documents and bank statement and purchase and sale agreement on a car, which altogether indicate that in 2016 spring, my mother had certain savings accrued in euro and US dollars on her bank account, and following the purchase of the vehicle throughout 2016, my mother no longer had the savings, and she bought currency in small batches up into 2020-21, when again she accrued some savings.
You say that your mother obtained the 10,000 or 15,000. It was by $3,000 that were joint savings with your late father. That she received 500 euros. Your mother received from a friend. There were a few pension payments, which from $50 to $300 per month. There was a payment by a tenant, 500 hryvnias per month. And there was a monies received from someone who died. And that your mother, with quite little income, had a vegetable garden, grew vegetables and fruits and berries, kept the goats and chickens, so she didn't need any money to live from. That is your explanation, is it?
I would like to say, when you stated the source of savings and income, you mentioned $5,000 from a friend. That did not happen. It says that when my father died, his friends provided 500 euros, three of them. No one gave her the 5,000. But overall, I did list the different sources from which she was receiving an income from the period of 2013 until 21.
Yeah, but in any case, what you say is that your mother, who had a little small income, lived from her garden and her chickens, and she invested the money she had into cryptocurrency that later she gave to you. I now pass the floor again back to Mr. Melnick for additional questions.
Mr. Chairman, may I reply to the last statement made by Robert? And it wasn't a question. Was it a question, or did you just recap what you've heard?
I recap what Of course, the candidate has a right to respond to my remark.
Fine, please. According to the answers that I have provided to the international experts, I stated that if we sum up all the sources of income of my mother, they are not that insignificant, and it permitted her to gradually, over 5 years, to accrue the savings of $10,000 that she had handed over to my brother. And out of the 10,000, she had received 4,000 as an heir of Mr. Meslitin, who left his assets in his last will, and his will was opened in 2018. Thank you. Thank you, Robert. Thank you for this opportunity to pose my questions to Mr. Kimstachov. So, may I reply to the statement that the mother's income was not so insignificant to raise doubts, and her ability to give gifts? I would like to say that we use the sources that are official, and one such source is the data contained in the tax register. And the income of your mother isn't striking. Since 1999 till 2024, there's information about several counter agents, the 3 of them, Pechenif, a district employment center, and that's 32,000 over the time. The social protection service, 12,000, and limited liability company, Agro, 19,000. I would say it's not very impressive for a person to make such expensive gifts. So, would it cause doubts about her ability to give you a gift, or most of the income that you had mentioned were not officially confirmed in any way? The tax records have the information received by my mother. The tax does not contain the information about the payments made by the pension fund. And since 2015 onwards, I provided the data to the international experts, and the pension is quite sizable. Since 2018, as the widow of the serviceman, she received 30% of his pay, which is about 5,000 hryvnia a month. As for other sources of income, the income as inheritance of Mr. Merzlikim is reflected in the register that she had received the inheritance, and she registered her ownership title. I understand about the inheritance, but you do recognize that the tax record does not contain some sources of income, so we can't find the confirmation of this income in the register. This is the nature of my question and the essence of your answer. And in addition, frankly speaking, we live in a country where the retired people are unlikely to have savings to buy cryptocurrencies. This is rather an exception to the rule rather than the rule. If I may briefly reply, in the 90s, we were hard-pressed, and they told her to put away any money she could as saving. And she wasn't saving to buy cryptocurrency. The question of handing the cryptocurrencies to my brother arose in 2020 when they talked amongst themselves, and the brother persuaded her that it would be better and more make better sense than keeping the money at home in cash. The next question. According to the Unified Register of Powers of Attorney, on the 28th of October 2020, Murashkina Maria Volodymyra issued a power of attorney in your name to represent her interests. What was it about? Indeed, such a power of attorney was issued in connection that she was the heir of the property after the death of her father, and she asked me back when I was still a lawyer to help her document the inheritance in her name. She lived in Odessa and was studying there. She didn't have the chance to travel to Uman to attend to the matter personally. So for me to be able to submit the documents in her interest in the court or to the notary, she issued the power of attorney in my name. So you're stating that the power of attorney was issued because of your acting as a lawyer. This was the time when I was a lawyer and I did help her in the capacity of the lawyer. What would you say that your license was suspended on the 22nd of October 2020, so a year before the issue of the power of attorney. I started helping her. In 2019, I drafted a claim to the court and I received the documents from a notary in 2020. The decision was made by the court. The judgment was issued by the court to receive the judgment and pass it to her and complete the documentation of the inheritance. She issued the power of attorney by May. How long have you been the assistant to the judge of Hacks? September 2019. So I would like to underscore that working as the judicial assistant since September 2019, you received in October the same year a power of attorney, or rather next year, having a year been in the position, and it's the court staff, which it is under certain limitations, the anti-corruption limitations too, and you still offered legal services to an individual with whom you had legal relations back when you were a lawyer. Is my understanding correct? I would disagree with you because the anti-corruption limitations were imposed for the 2019 and then changes were introduced into law on the prevention of corruption, and the patronage service was exempt from the limitations. And I would say that as such, I did not offer any services. She did issue a power of attorney in my name, but I was living in the city of Kiev and working for the High Anti-Corruption Court. I did not travel to Uman. I did not attend to the case. I explained to her how she could obtain a court judgment and where to go to finalize her inheritance with which notary. I did not take any actions in her interest. Fine. Then the next question will pertain to the data from the Unified Register of Individual Taxpayers. So in 2019, 2021, and 22, we received their income 19, 427,000, 20, 756,000, and I'm rounding it, 21, 793,000, in 22, 1,120,000. Could you please explain the numbers and what were they from?
In the period between September 2019, I worked as an assistant judge, and the salary for the assistant judges at the High Anti-Corruption Court are quite high. And according to the tax administration, this is the amount of money I received as a salary. For example, in 2020 it was 700,000, and 21 750,000, 22 and 23. These were smaller amounts of money, about 600,000 hryvnias, a little more. My revenues in that period, including in 2019, also consisted of my pay, the money I received for renting out my apartment in the city of Uman, and several 100,000 hryvnias is the awards that were awarded by my banks. And I also sold some office furniture in 2019 that I purchased when working as a judge to use in my office. Then in 2023, my income consisted of the pay I received at the HACC and the money I received for selling my apartment in Uman. In 2023, in addition to the pay as an assistant judge, I also received an intangible asset from my mother with the amount equivalent to about 550,000 hryvnias. All of my revenues were declared every year. Starting 2012, I've been submitting the declaration every year, or in my tax declarations as a civil servant, and I reflected there all of my revenues. And to confirm those revenues, one can see that in the bank documents, and as regards the contracts for renting out my apartment, I even have the original of those contracts, and one can see who I had those contracts with and for what amounts of money. Fine, I understand. That means you assert that all the information, the tax declaration, has been completely reflected by you and the anti-corruption declaration, and you didn't have any other sources of revenues during that period. Thank you. Allow me. I also take into account the 2 months during which I worked as a lawyer, and I declared also the money that I earned during 2019 as I worked as an assistant judge. Okay, I understand. It's important to say that you did not submit the declaration, the anti-corruption declarations, because you were not obliged to do that in that period. Yes, in 20 and 21, I did not submit such a declaration, but in those same years, I submitted my tax declarations that contain the figures about all of my revenues. I understand. Now about purchasing the cryptocurrency. In 2020, in the chapter 10 of the declaration, there was a new chapter that reflected the crypto assets owned by the subjects of declarations. You wrote there that you had cryptocurrency for the overall amount of 750,000 hryvnias. In the previous declarations, this information was not there. How did you acquire those assets? Did you accumulate that? And with which money you purchased those crypto assets? The first time I purchased crypto assets in February of 2021. And in the period until June of 2021, via my bank account in Privat Bank with my hard currency card, I transferred to Binance Exchange the overall amount of the total amount, $15,600 from a private bank card. About $11,300 were transferred, and the remaining $4,000 was the loan that my brother had paid back to me after I had given him Ukrainian currency, and he paid it back to me by transferring some kind of coins for me by using the crypto exchange. I understand that your brother actively works with crypto assets, and he owns some crypto assets. Yes, it is so. This is the money that is reflected in the declaration where I purchased the crypto assets. This is the money that I have saved from my salary as an assistant judge. I mostly purchased the currency via private bank. That is, the money from my salary card were transferred to the hard currency card, and a part of the money of the cryptocurrency was purchased with cash at the exchanges. All the crypto assets that I have mentioned in my declaration of 2022 and 2023 were formed by exchanging the money that had been saved before that, exchanging into another kind of currency. In other words, my crypto wallet received 15,000, and later those 15,000 were used to purchase all kinds of other crypto coins, and I didn't invest any more money. Thank you. The other thing you've just mentioned, that periodically you loan something to your brother and then he pays this money back to you. What amounts of money are you talking about, and what that happened in those periods where you had to cover it with your declarations? These were not significant amounts of money. It could be between 3,000 to 19,000 hryvnias. It could be several times a year, because at certain points in time he needed to get some amounts in the Ukrainian currency, hryvnia, so he asked me to transfer those, to give him those money, because these were insignificant amounts of money. They were not to be declared. Is that right? Yes. Thank you. Now, as regards alienation, or rather getting the profits as you alienated real estate for the amount of 440,000 in 2022, clearly you carried out a legal deed, although probably you forgot to mention it in the declaration. What kind of a legal deed was it? What was alienated? I have to note that according to the rules of filling the declarations by the candidate judges, the candidates are not to fill the sections about the legal deeds. This is the rule coming from the law. Yeah, for the note, I confirm it is so. Candidate judges are not to fill in the section on the legal deeds. That's true. Therefore, I notified about the income of 440,000 hryvnias. It is also reflected in the tax declaration. The amount I mentioned there was lower. Why did you mention a lower amount of money? Sorry, I'm going to tell you now. On the 5th of November 2022, I signed a contract of purchase and sales of the apartment in the town of Uman, and the apartment that I owned, and that contract, I have a copy of it, and I can submit this document. According to the contract, the price of the purchase or sales of the apartment was 440,000 hryvnias that the buyer transferred to my bank account in Privat Bank. And that transaction can be seen by looking at the bank documents. And the payment was made in several installments because in 2022 there were certain restrictions for one-off payments. Why was the amount different? The amount that one can see in the contract and my tax declaration. Let me explain that. According to the certificate of the value of the real estate provided in November 2022, the value of it was 335,000 hryvnias, and that was the assessment value that was provided by the notary to the tax administration, and therefore it was declared in my declaration. While 440,000 was a higher price than the evaluation value. Thank you. The NGOs that provide supervision over our procedures have some doubts about the validity of the market price for which such an apartment could be sold. Is it so? No, it is not so. As I just said, on the 3rd of November 2022, a certificate of the assessment value of the real estate was formed on the basis of the information from the State Property Fund, which is taken for the information to be provided to the tax administration. Yeah, but you said that the value in your certificate and the amount of money that you sold your apartment for was different. So therefore, there was nothing that prevailed you from agreeing to a higher amount of money, but you agreed to 440,000. Why? Because the apartment was in a bad condition. Why the apartment was sold for that amount of money? Or was that a kind of a free agreement between both parties? How you can explain that? Yes, the agreement with the buyer was that he would buy the apartment for 440,000 hryvnias, and the money was paid in by transferring the money. Why was that amount of money? 2022, the armed aggression of the Russian Federation against Ukraine was continuing, and the cost of real estate had gone down on the one hand. On the other hand, there were some peculiar features related to that apartment and its location. One can say that that house, it's a living quarter of about 10 houses, which is on the other side of the Odessa-Kyiv highway, rather than the other part of the city. So in fact, it's a suburb of the city. It's true that the state of the apartment was, it hadn't seen any good renovation. The kitchen and the corridors, nothing had been done to that apartment after 1975. The repair work was done in one of the rooms only in 2015, where some laminated floor was put on the floor and the wallpaper was renewed. So in fact, the apartment required additional money to be renovated. Plus, another peculiar feature of that house was that at the time when the apartment was to be sold, that was the only apartment that still had some centralized heating system. All the other apartments already had autonomous heating systems. In other words, the cost of heating that I had paid, well, I no longer paid for heating in 2019 by the persons who rented that apartment, and the new owner had to pay. were 2 or 3 or times higher than what the other owners of the other apartments paid. So you believe that all those factors in total explain that price of the apartment? Yes, thank you. Okay, now as regards the loan that you received from your brother in the amount of $14,000 in 2023, I understand that, going slightly ahead, this is the money that you eventually used to buy your apartment later, but let's start with that loan. What money was that? Some kind of savings, or or how did you receive that money? Was that via crypto exchange once again? The money you received from your brother? I understand your question. As I have explained it to the international experts, and I provided information from the tax register about the amount of money earned by my brother Serhiy in the period between 2016 and 2022. Except for 1 year, he was an entrepreneur, he had his business, and he declared his revenues that were quite significant. In other words, you are saying that the origin of those revenues can be explained with some official sources that have been declared, and the information can be found in the declaration register, and that explains that your brother had a possibility to give you that loan. Is that right? Yes, or there were some other sources of revenues that your brother informed you about. Well, I have already provided that information, that between 2016 and 2023, the total revenues of my brother, in view of the average exchange rate every year, was about $273,600. That means he had savings, and most of his savings were really transferred into cryptocurrency. Some of them were kept in cash. He gave me a loan in the form of cash. I went to see him to the city of Kharkiv. We had that contract loan agreement. I have the original loan agreement with me, and that was the $14,000 he loaned to me in cash. Yes, I understand. All right. Now the question related to the apartment you purchased in 2023. The apartment that is owned to you and to your wife, owned by you and your wife. Did you have enough money to buy that apartment? Where did you get the money that you missed at that time, that you lacked? Did you use your cryptocurrency, crypto assets at that time? Did you need to alienate those assets in order to buy the apartment? Or did you use any other money coming from other sources? The apartment was purchased in November of 2023. $3,724,000 hryvnias, which was the equivalent of $98,000. This money consisted of the savings, my savings and my wife's savings that I had reflected in the declarations and in the candidate declaration. That was the first part. The second part was the loan from my brother in the amount of $14,000. And there was also a loan from the head of a department of the organization where my wife worked in the amount of $4,000. And therefore, we have a copy of the letter written by Mr. Fomenko saying that he loaned $4,000 till the end of 2023. And in the period during 2023, starting with between spring and November, I alienated about 90% of the crypto assets that I owned. in order to add that money to the amount of money I needed to purchase the apartment. I need to state about the consequences of the actions related to the loan I received from my brother and the present I received from my mother. As I said, my mother transferred this intangible assets to me in October and November 2023 to my crypto wallet, and that was also the amount I needed to buy the apartment in Kiev. But I did not manage to use those crypto assets because a certain fraud has been carried out against me. In effect, I lost that intangible asset. After that, I turned to my brother with a request to loan me the amount that my wife and I did not have. That was 14,000 US dollars. I understand. All right. So you are asserting that you had enough money of your own plus the money that had been loaned to you to buy the apartment. The price of the apartment is a proper market price, right? There shouldn't be any doubt about that. If we analyze the real estate market today in terms of technical state of the apartment has the right price. Yes. Well, I would just like to. Yes, the state of the apartment meets its requirements, and as regards the purchase of that apartment for $98,000, we had signed an agreement back in May of 2023 where my wife and I had a preliminary agreement with the previous owner in order to amass the proper amount of money. We agreed that we would buy it in October, but because of the situation where I lost the money, it was delayed until November. Oleh, thank you very much for giving us frank answers. Just one note, allow me. If one has any doubts about the price, I have a screenshot of an announcement at the Realtor website where that apartment was to be sold at the amount of 95,000 US. And one could see those announcements made by the realtors who originally wanted to pay or receive $77,000. As a matter of fact, our proposal became the best one. Dear Commission members, there's the end of my questions. Colleagues, would you have any more questions? Please.
Oleh, what should persuade us that during the next competition, let's say to the Constitutional or Supreme Court, or should God forbid there be disciplinary proceeding, you will not lay down the powers of the judge of the hack and you will not repeat what you had done before? I've been a hack employee for over 5 years already. I enjoy the atmosphere. I appreciate the team that I work in. There's mutual understanding amongst the staff and the judges, the management of the judge, the head of the staff of the court and the staff. The management made sure there's the best atmosphere, working atmosphere compared to other courts in Ukraine. So I feel I want to stay with the court as long as I can. And I have no intentions to jump the positions in the near foreseeable 10 to 15 years. Please. Ruslan Sidorovich, the member of the Commission. I have a brief question, and I may ask one or two follow-up questions after that. I'm interested in the story that you had told us a sad story that had happened to you about the fraudsters, that you've been defrauded and you lost the crypto assets that you had owned. Could you give us more detail into the events? How did the fraudsters manage to defraud you, break your trust, and defraud you of this volatile but still quite an attractive asset for investors? Let me say that my mother had handed the cryptocurrency in stable coins, which is a stable cryptocurrency, which is an equivalent to $1 plus one decimal or so. On the 21st of October, my crypto wallet received the assets in total 15,000 USDT. So I had to sell the asset in order to receive the fiat currency to buy the apartment. So over the internet, I was looking for people, or rather organizations, that could offer the services of off-ramping from cryptocurrencies into fiat, and I found one such organization. They asked me to send the information about the owner of the crypto address and go through the check as to the origin of the crypto assets, whether they are risky or not, whether there are any reservation about legality of the crypto assets, and send me a link to a site where I would go through such test. Initially, I did go through the test, not at the link, but following the address, and it indicated that the money is clean, untainted. It's not, my crypto address was not a risky one. It did not raise the doubts about the legality of the crypto assets. But then the individuals insisted on me taking a more detailed and thorough test following their link. So I did follow the link, and as a result, an automatic contract was imposed which transferred the money from my address to their address the same day. I filed a complaint with the cyber police, and then my complaint was handed over to Darnitska police station to investigate. Oleh, I have a question in this connection. Personally, do you take yourself as a trusting person? Let me put it this way. In my life, there's been a case or two where I had negative consequences because of me trusting people that I had dealt with. Generally, I am critical of what I'm told, and in my line of work, I didn't have times when I would have been misled. This was a case of when I needed to off-ramp the money quickly, and that led me into making a mistake. Oleh, I raised this question naturally, perhaps because corrupt officials are people creative, and you are vying for your position of a hack judge and being trusted in your own interest. That is a violation of principle of reasonable scrutiny and you only harmed yourself, but you being trusting on the position of a hack judge could be more dangerous. So this is something that is a concern. But anyway, thank you for your answer. If I may make a remark, I do understand how it may be construed, how it may be perceived. In 5 years, I've handled many cases to do with corruption, and I have the experience of analyzing the documents and the testimony of individuals and corroborating different sources of evidence to establish the facts of the case. Thank you. Colleagues, any further questions? You're welcome. Serhiy Chumak, the member of the Commission. I will continue on the line of questioning of Ruslan to try to understand the logic of your action. Some time ago, when you answered the question of my colleagues, you had stated that your brother knows about cryptocurrencies. So the question is, why didn't you ask an expert to prevent the predicament? If I don't know much about cryptocurrencies, I wouldn't take any actions independently to risk being defrauded by fraudsters. If you could please explain your logic, because you had told us that your brother has the right skills in this field. Thank you. I do admit that at the time I did not take advice of my brother before I took any action. The mechanism of alienating the cryptocurrency was clear to me, and at the time I had the experience of selling crypto assets through Binance exchange when the money was transferred to a bank account, and I did not ask the detailed advice of my brother, and I did not turn to him for advice. This is true. I hoped or expected that the counter agent would act in good faith. Any other questions? The esteemed representatives of the Public Council of International Experts, do you have any questions remaining? Я поглядаю на своїх колег, пане голово.
We don't have any further questions. Thank you. And thank the candidate for his attention.
Дякую. Олег Сергійович, дякуємо вам за
Oleg
щирі відповіді.
Sergeyevich, thank you for your candid answers. If need be to provide any additional information, you're welcome, but please let it be brief. I referred to some documents that I hadn't sent to the Commission prior. So my question is, would you accept the documents such as the loan agreement, the IOU note, the purchase and sale agreement on my apartment, and the lease agreement of my apartment? When did you send the documents? I have not provided the documents. I have them with me for this hearing. I was not asked the question specifically before. You have the right to submit the documents, but the general rule is that you had to submit the documents prior to this hearing. So if you feel that are significant and important for the consideration of this matter, you can provide them, but later we will discuss amongst us whether we will admit them to the case file or not. We will not decide on the matter now. With your permission, then, I will hand the materials over to the representative of the Secretariat. for the broadcast.
В розгляді питання оголошується перерва.
A recess is announced.